speed. That's it. Alleged speed at that. Disputed speed. Undefined speed. Undefined speed. And now, after apparently abandoning that exact theory, which is what they argued at the preliminary hearing, they want this court to treat speed alone as implied malice. And that is not the law. That brings us to the fundamental problem in their briefing and in the magistrate's ruling. The prosecution has misstated or did misstate at the preliminary hearing the legal standard, and the magistrate clearly accepted that incorrect standard. They collapsed the two prongs of implied malice into one, the two prongs being the objective and the subjective into one prong. And they continue to do so even as recently as their reply. The reply brief that we received this morning states, quote, "The objective and subjective determination of the lethality of speed." That is a direct quote from the prosecution's reply brief from this morning. They still are conflating and combining the objective and the subjective factors, and the law says you cannot do that. And they're doing it on the back of, quote, "the lethality of speed."
Well, it appears that the judge who held the defendant to answer believed so, when in his holding he said, quote, "Implied malice requires that the defendant act with a wanton disregard of a high probability of death." That's from the preliminary hearing transcript, volume 3, page 47, lines 14 through 15. The committing magistrate clearly understood the law and applied the law to the facts that he heard. And we're here for a 995 motion. And the question then is, were there sufficient acts for him to draw that conclusion? Understanding he was applying the very law the counsel's been saying he did.
This is describe it. They put different numbers on it, but they all said things like he was going, quote, extremely fast, or he, quote, flew past me, or he was going, quote, super fast, or that he, quote, accelerated extensively. The data recorder in Mr. Bohm's car said he was doing close to or even above 100 miles per hour in the instance before the crash in a 45 zone. The magistrate noted the data recorder evidence carried weight in his decision-making, acknowledging that while there are warnings that come with it that say it can make mistakes, there was no evidence presented at the preliminary hearing in this case that it made errors here.